5 seconds to go. Start. That would amount to saying that the time limits prescribed by the parties in the agreement have no significance or value and that they mean nothing. Would it be reasonable to say that because time is not made the essence of the contract, the time limits specified in the agreement have no relevance and can be ignored with impunity? It would also mean denying the discretion vested in the court by both sections 10 and 20. It is clear that in the case of sale of immovable property, there is no presumption as to time being the essence of the contract. Even if it is not of the essence of the contract, the court may infer that it is to be performed in a reasonable time if the conditions are evident from the express terms of the contract, from the nature of the property, and from the surrounding circumstances, for example, the object of making the contract. In other words, the court should look at all the relevant circumstances, including the time limits specified in the agreement, and determine whether its discretion to grant specific performance should be exercised. The court, keeping in view the fact that it exercises a discretionary jurisdiction, would be entitled to take into consideration as to whether the suit had been filed within a reasonable time. What would be a reasonable time would, however, depend upon the facts and circumstances of each case. No hard and fast law can be laid down, therefore. The conduct of the parties in this behalf would also assume significance. We, therefore, are of the opinion that interest of justice would be subserved if this court refuses to exercise its discretionary jurisdiction in terms of section 20 of the act, directing the defendant to pay a sum of rupees 60,000 to the plaintiff, which sum would include the amount of advance paid by her. This court reiterated that while exercising discretion in suits for specific performance, the courts should bear in mind that when the parties prescribed a time for taking certain steps or for completion of the transaction, that must have some significance, and therefore time period prescribed cannot be ignored. The courts will apply greater scrutiny and strictness when considering whether purchaser was ready and willing to perform his part of the contract, and every suit for specific performance need not be decreed, namely because it is filed within the period of limitation, by ignoring time limits stipulated in the agreement. The courts will also frown upon suits which are not filed immediately after the breach refusal. The fact that limitation is 3 years does not mean that a purchaser can wait for 1 or 2 years to file a suit and obtain specific performance. The 3-year period is intended to assist the purchaser in special cases, as, for example, where the major part of the consideration has been paid to the vendor and possession has been delivered in part performance where equity shifts in favor of the purchaser. Stop.